From supplementary list, item number 1, pronouncement of judgment.
I'll read out only the operative portion.
Yes, sir.
Apparently, the petitioner has failed to secure a place as one of the successful candidates in the merit list, and as such, she could not have been appointed. A case for regularization in the light of such subsequent circumstances cannot be sustained. In view of the above, this court is convinced that the petitioner has not been able to make out a case for consideration by this court. This petition is found devoid of merit and dismissed as such.
Much obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 2 to 8. These are connected matters, Your Lordship. I pray that these matters come up after 2 weeks, Your Lordship, as my senior counsel is in bereavement.
His mother-in-law
Pass away.
passed away. So he's in Manipur. So
Manipur. These are all connected matters.
Yes, Your Lordship.
Prayer has been made for accommodation on behalf of Senior Counsel Mr. H.L. Sangresu, appearing for the respondent number
4 to 5.
4215 on account of his bereavement. Mr. S.S. Sheikh, counsel for the petitioner, and the other counsels appearing for the other, and the counsels appearing for the other respondents have no objection to the prayer made. Accordingly, same as allowed. This is matter after 2 weeks.
Obliged.
May it please Your Lordship. Your Lordship, I beg to mention item number 10.
Number
10, Your Lordship. Your Lordship, I pray that this matter may come up after 2 weeks.
after?
2 weeks, Your Lordship.
Why? On what ground?
Pardon, Your Lordship.
What is your ground for adjournment? You are appearing for petitioner
Yes, Your Lordship.
on plea made by Mr. The counsel has sought for accommodation on ground of personal difficulty of the direct conducting counsel. As such, matters adjourned. Let's see after 2 weeks.
Let it be 3 weeks, Your Lordship.
3 weeks.
Obliged, Lordship.
Daily list, item number 1.
Excuse me. Yes.
Your Lordship, as per order,
What do you want? Just
Your
please
Lordship,
make a submission
actually,
before the honorable.
Your Lordship, this case, it's been in the order dated 25/10/2024. The parties had submitted that it's still pending before a similar matter is still pending before the division bench. So Your Lordship may kindly have it after.
Why?
In fact, that has been clarified, Your Lordship. That matter which is pending before the division bench has no relevance with the issue in the case, Your Lordship. This is a toolkit, the so-called non-tribal toolkit, whereas in the matter pending before the division bench that is a customary collection of toll, Your Lordship. So it has no relevance, Your Lordship.
What is the order?
Lordship, a submission has been made that a similar matter is pending, Your Lordship, before the division bench. In fact, Your Lordship, in my humble and respectful statement, that is not there. Because the issue where Lordship will recall that Himamolong case,
Yes.
Lordship. So that issue there, which Lordship had decided that matter. The Lordship will recall, Your Lordship, it has no bearing in the present case, Your Lordship. Because that is a customary collection of toll by the traditional chief of Himamolong, Your Lordship. Whereas this is the collection, Your Lordship, the so-called non-tribal kit, checking on whether the non-tribal transport they are having a valid trading license or not, Your Lordship. That is the issue here, Your Lordship.
What is your case here?
Your Lordship, the facts of the case is that there were 3 check gates that were closed down by the respondents. It was closed down by impute letter number. It's 3 letters. It's dated 25/2/2022, 1 letter, and the other impute order is dated 12/7/2022. They have closed down the check gate at Mukindur, and that is the reason why we have come before this court.
Is this the, if I recall correctly, is this the one that was
Your Lordship,
shifted
had
from
gone.
Mukundur to Klitrishi?
Lordship,
If I may, Lordship, your Lordship is correct. That check gate was shifted. That was pertaining to another matter, Lordship.
Oh,
that is a different case,
but
Your Lordship.
it concerns the same check gate. It was moved from Mukundur to Klitrishi, Lordship. One of the check gate. That matter is.
Oh, that's a different case.
That is a different issue
That is a
altogether.
different issue. But so far, one of the check gate that was moved from Mukundur to Klitrishi now.
What is your case here?
Lordship, here in this case, what has happened is the government has issued an order directing us to close the check gates.
Okay.
So now, against that, we have come before Your Lordship. Your Lordship had dealt the matter in the interim application, and Your Lordship had granted us.
There was the stay order is operating, Your Lordship.
It's operating. So we're running the check gate, Lordship.
Then you see, stay order cannot be sustained for long.
Lordship, exactly, Lordship.
And
What is stay? Say interim. The very word interim means in the meantime.
Lordship, Lordship is correct, Lordship. Lordship, you can come after 1 week, Lordship, and expedite the hearing, Lordship.
Since 2022.
Lordship, it has gone before the other court as well. Then the other court had personal difficulties, Your Lordship. So it has come back before Your Lordship.
and this collection also, yesterday I was Lordship of the Proceedings, Your Lordship. I was watching in the YouTube. I saw one truck driver. I happen to be a YouTuber. He has mentioned all this collection from Riboy area till because he went from for carrying cement from Star Cement, Your Lordship. He was.
What you see, we don't know.
Yes, Your Lordship.
Legality of that action cannot be determined.
Because these check gates are set up under the regulation, Lordship.
Lordship,
So far as my senior counsel is mentioning about the YouTuber, we don't know, Lordship. Maybe that is not within our also. So far as collection is concerned, the check gate is
that has to be seen, Your Lordship, whether that collection is
check
legal or not.
The license, whether the vehicles they carry any license or not. So that is done under the regulation, Lordship. That is done under the regulation.
Whether that power is there or not, Your Lordship.
We'll have it after 2 weeks then.
After 2
Be
weeks,
sure
Lordship.
we'll get it.
Lordship. In fact, this is the matter filed by the District Council, Lordship, JHDC.
Oh,
This is not a private, this is by the District Council, Lordship.
any private
No, Your Lordship, there is no
Lordship.
private
It's not private.
party, Your Lordship. This is this council versus the state, Your Lordship. Because their Lordship, the state has adopted a zero tolerance towards this check-it, Your Lordship. So by virtue of that, Your Lordship, order has been issued to dismantle all kit which is running illegally, Your Lordship. Here in this case, Your Lordship, they have taken shelter in one of the cases decided by the division bench, Your Lordship. That is Mayanti small lot case, Your Lordship. And there in that case, Your Lordship, even the division bench also has said that this power can be questioned by anybody, including the state. So that's why, Your Lordship, we have filed the affidavit questioning the authority of the district council to make that kind of collection, Your Lordship. Tell us, please, Your Lordship. Under the regulation, they say under the regulation, but under the regulation, Your Lordship, there is nothing as such, Your Lordship.
The subject,
Your Lordship.
Lordship, the subject matter is not that, Lordship. The subject matter in this case is whether the District Council can set up the check gate along the national highway, Your Lordship. That is the impunity.
That also,
That
Your
is the
Lordship,
impunity.
that also one of the stand taken by the state, Your Lordship. By virtue of the National Highway Authority, Your Lordship, because the National Highway Authority, Your Lordship, that power vests with the central government, Your Lordship. Here also, Lordship, it is within the National Highway, Lordship. They need a prior permission, Your Lordship.
So basically,
yes, I think if I recall, we'll look into it.
Lordship,
It's
yes.
That, you see that, what do they call it? The distance.
A
the
Lordship,
distance, Lordship,
Lordship,
3 meters.
If you go by the regulation, that Assam regulation, Revenue Regulation 1886, Your Lordship, from the middle of the road, 35 to the left and 35 to the right, Your Lordship, 35 meters, Your Lordship, that is the right of way, Your Lordship. Nobody can claim right over that right of way, Your Lordship.
if
So
the
you
national
take by that
highway,
logic, Your Lordship, even if the kid is situated, say 5 meters, 10 meters, Your Lordship, that will
No,
fall
if it falls
within the
within-
right of way, Your
If it
Lordship.
falls within that zone, then
Lordship, yes. Lordship, I'll refer
Lordship, if the submission made by the my Lynette Senior says that that the gate is erected in national highway without the permission from the national highway, then in fact the impugn order is without jurisdiction, Your Lordship, because it's issued by the state government, not by the national highway or the central government.
Lordship,
That is the-
Lordship, the district administration, Your Lordship, he has the power, Your Lordship. He has the power, Your Lordship. And recently also, Your Lordship, there is the Honorable Supreme Court has also directed the national to remove all encroachers, Your Lordship. That judgment also I'll place before Your Lordship.
as paid for by the parties. This is matter 2 weeks.
Oblige, Lordship.
Highly obliged, Your Lordship.
Item number 11.
Yes.
Me, please, Your Lordship. Lordship, this is an appeal.
You are ready in this matter?
I'm ready.
How many respondents are there?
Just two, my lord. And number one is represented. Number two, it has gone ex parte, my lord.
Number one, who is number one?
The claimant.
Claimant.
Claimant. And number two is the owner. It has gone ex parte against. I'll start here. My lord, a fairly unusual matter. This is why I say it is an unusual matter, my lord, is for the reason that in this case, there was no accident as such. There was no accident as such. There was a murder committed. A murder of the son of the claimant. It just so happened that at the relevant time, he was a handyman of a vehicle, of a Tata Sumo. That handyman, that vehicle, my lord, had been requisitioned or had been taken over by some miscreants.
Yes.
And miscreants, my lord, ended up murdering the handyman, the son of the claimant, and the driver.
Yes.
So because, my lord, at the relevant time, as I said, there was a vehicle involved, in the sense that the handyman, the son of the claimant, and the driver were in that vehicle. This MSC case has been filed. We had raised an issue of jurisdiction, maintainability, etc. Learned MSCT, my lord, did not agree with us. Learned MSCT has gone on to to pass an award of 11 lakh something plus interest in favor of the claimant, my lord. It is against that award, my lord, that we have come before this honorable court. Now, my first request to this honorable court is to kindly look at the nature of the claim that has been filed. That is apparent, my lord, from page 15. My lord. Lordship will see the cause title, an application filed under section 163A and so read with section so and so of the MP Act. So this was not a section 166 application.
Okay.
This was a section 163 application. And Lordship is aware, a section 163 application is governed by the second schedule, my lord. It's controlled by the second schedule.
Yes.
Now,
so where the amount of compensation is determined?
Is more or less determined, is more or less a set amount, my lord. Now, section 163A, if Lordship is kind enough to look at the precise wording of 163 motor vehicle.
We have the new act now.
Now we have the new act, but this was under the old act, my lord. This was still it was filed, the accident, the murder took place at that time before the amendment.
163A. Yes.
If I'm allowed to read, my lord. 163A, special provisions as to payment of compensation on structured formula basis. Number 1. Notwithstanding anything contained in this act or in any other law for the time being in force or instrument having the force of law, the owner of the motor vehicle of the authorized insurer shall be liable to pay in the case of death or permanent disablement due to accident. In the case of death or permanent disablement due to accident arising out of the use of motor vehicle, compensation as indicated in the second schedule to the legal is so on and so forth. My point, my intention behind reading this is to highlight before this honorable court that for section 163A to apply and for an award to be passed in 163A, there are two requirements, my lord. One, there has to be an accident, and number two, my lord, that accident has to arise out of the use of motor vehicle. So there has to be a nexus between the accident and the use of motor vehicle, my lord. Now, in this case, it will be my attempt before this honorable court to demonstrate that, number one, there was no accident. And number two, even if it is to be considered or deemed or assumed that there was in fact an accident, that accident did not arise out of use of motor vehicle, my lord. On the first point, whether or not there was any accident, my first submission is that there was no accident. It was a case of murder. It was a case of murder. Now, murder, my lord, we are all familiar with the definition of murder. Supreme Court, my lord, has drawn a distinction between a murder simpliciter and an accidental murder, my lord. An accidental murder. So, if there is a murder simpliciter, Supreme Court has gone on to say that an MSCT claim is not tenable, is not maintainable. If it is an accidental murder, where murder was not the primary intention of the action, but it just so happened that by accident murder was committed, then maybe an MSCT claim can survive, is maintainable. if I'm allowed to give an example, and this is an example that Supreme Court also has referred to, that if a vehicle is taken over by some people, they want to steal the vehicle, my lord. They want to steal the vehicle so their primary intention is theft. But in the process of stealing the vehicle, the driver intervenes, etc., and he is murdered. Then that is not a murder simpliciter, it is an accidental murder, because murder was not the primary intention, my lord. So only if it is an accidental murder can a MST claim lie, subject to other provisions of law. But if it is a pure murder, a murder simpliciter, a MST claim shall not lie, my lord. My lord, the leading authority in this respect is a judgment that was passed by Supreme Court quite some time back. This was in the case of Rita Devi, my lord. Now, Rita Devi was a 2000 Supreme Court judgment. In this extract, my lord, if lordship kindly looks at para 10 first.
Yes.
I'll read, my lord. The question, therefore, is, can a murder be an accident in any given case? There is no doubt that murder, as it is understood in the common parlance, is a felonious act where death is caused with intent, and the perpetrators of that act normally have a motive against the victim for such killing. But there are also instances where murder can be by accident on a given set of facts. The difference between a murder which is not an accident and a murder which is an accident depends on the proximity of the cause of such murder. In our opinion, this is important, my lord, in our opinion, if the dominant intention of the act of felony is to kill any particular person, then such killing is not an accidental murder but is a murder simpliciter. While if the cause of murder or act of murder was originally not intended and the same was caused in furtherance of any other felonious act, then such murder is an accidental murder. So the distinction between a murder per se and an accidental murder has been set out in this para 10, my lord. So there could be situations when the main intention is the murder. There could be situations when the main intention is not the murder, but it is incidental. It just so happens that murder was committed. Para 14, my lord. Next page, my lord. I'll read, my lord. Applying the principles laid down in the above cases to the facts of the case in hand, we find that the deceased, a driver of the auto rickshaw, was duty bound to have accepted the demand of fare-paying passengers to transport them to the place of their destination. During the course of this duty, if the passengers had decided to commit an act of felony of stealing the auto rickshaw, and in the course of achieving the said object of stealing the auto rickshaw, they had to eliminate the driver of the auto rickshaw, then it cannot but be said that the death so caused to the driver of the auto rickshaw was an accidental murder. The stealing of the auto rickshaw was the object of the felony, and the murder that was caused in the said process of stealing the auto rickshaw is only incidental to the act of stealing of the auto rickshaw. Therefore, it has to be said that on the facts and circumstances of this case, the death of the deceased so-and-so was caused accidentally in the process of committing theft of the auto rickshaw. So in this case, my lord, what had happened? Some people entered an auto rickshaw. They wanted to steal the auto rickshaw. That was the primary intention. In the process of stealing, my lord, something had happened. The driver was murdered. Supreme Court said that the murder was incidental to the main intention of theft. Therefore, it can be categorized as an accidental murder. The Supreme Court went on to say that such a claim is maintainable, my lord. In our case, what had happened was that the handyman, the son of the claimant, and the driver were on the way to Cleriath. In Cleriath, my lord, some people witnessed that certain persons had entered the sumo in Cleriath. Thereafter, there was no contact with the handyman or the driver. The next day, the sumo was found, and the bodies of the two driver and the handyman, they were also found. Sumo being found the very next day indicates very clearly that there was no intention to steal the sumo. The intention was and is was very clearly to kill these two persons. Why kill them? We don't know. Possibly we'll never know also, but that is a separate issue, my lord. Point is that there was the primary intention of the act of felony was to kill the handyman, my lord. So therefore, my submission is that it was a murder simpliciter, my lord. If Lordship looks at the evidence on record, Lordship will see page 34, my lord. Page 33, prior to that. Page 33, my lord, is the evidence of the IO of the case.
Yes.
Now, this IO, my lord, if Lordship looks at page 34,
Yes.
next page, right at the bottom, my lord, during cross-examination, I'll read, my lord. The last paragraph on 34. Later, he stated that that I am not sure whether the Tata Sumo is a tourist or private vehicle. The next day, the said vehicle was found from Morning Kreng. It is not a fact that one of the body does not belong to so and so, and this is important, my lord. And it is also not a fact. It is also not a fact that the reason for the murder of the deceased was for the purpose of stealing the vehicle. So IO himself said. Yes, my lord.
Who told him?
Evidence of the IO, my lord. Evidence.
With some source.
We'll have to go by what is on record.
We go by the scenario that you have depicted.
Yes, my lord.
Driver, handyman,
Yes.
Sumo disappeared.
Yes, my lord.
Later, Sumo found somewhere else. Dead bodies, both. Dead bodies found somewhere else.
At the same place, my lord, where the Sumo was found.
Okay. Whatever. Anyway.
So suggestion, because I was not the conducting also, but suggestion would have been put to him that the circumstances indicate that there was no intention to steal the Sumo, and he agrees, my lord. It is not a fact that the reason for the murder of the deceased was for the purpose of stealing the vehicle. So, that being the case, I reiterate my previous submission that very clearly this was a case of murder, my lord. This was not a case of accidental murder. Being a case of murder simpliciter, Honorable MACT, number one, should not have exercised jurisdiction. Number two, having exercised jurisdiction, could not have given any relief or any award in favor of the claimant, my lord. My lord, this matter becomes a little more simpler if Lordship looks at the division bench judgment of the Honorable Guwahati High Court that was passed in 2007 in a fairly almost similar situation. This is at page 4 of this compilation, my lord. Judgment compilation. It's Maya Rani Ghosh.
Yes.
This is a division bench judgment passed by Justice Ansari, para 46, my lord. So here, my lord, they were discussing about the Fatal Accidents Act.
Yeah.
Fatal Accidents Act and the interplay with the Motor Vehicles Act.
Yes.
So, but the principles that come out, my lord, are applicable in our case also. Para 46, my lord.
Yeah. Para?
46, 46.
Okay.
Para 46. In short, Motor Accidents Claims Tribunal deal with accidents which arise out of neglect or default. What is worth pointing out now is that person who uses a vehicle in a public place is that the claims tribunal, which are constituted under section 165 of the Motor Vehicles Act, decide only those cases of death or injury which arise because of neglect or default in the use of motor vehicles in public place. These tribunals do not deal with or determine any question of damages if a person dies due to wrongful act of a person, like a murder, my lord, due to wrongful act of a person who uses a vehicle in a public place. To make it more explicit, we may point out that when an injury or death occurs due to negligence or default, a claims tribunal constituted under the MV Act 1988 can determine the question of compensation. But if the person is deliberately killed or injured in a public place, the claim for compensation arising out of such a wrongful act will not lie in the Motor Accidents Claims Tribunal constituted under the MV Act of so-and-so. In such cases, the injured or the legal representatives of the deceased, as the case may be, shall have to necessarily take recourse to the provisions of the Act of 1855, Fatal Accidents Act, and seek their remedy in the ordinary civil courts. In short, the Motor Accident Claims Tribunal deal with specified classes of tortious liability, but in respect of claims for damages arising out of other classes of cases of tortious liability, the jurisdiction still remains vested in the civil court and would remain so vested in the civil courts until legislature creates a tribunal or some other forum for decision of such cases. What comes out is very clear and a very evident position of law. If a person is deliberately killed or injured in a public place, the claim for compensation arising out of such a wrongful act will not lie, cannot lie, my lord, in the Motor Accidents Claims Tribunal. If there is a remedy, that remedy has to be outside the Motor Accidents Claims Tribunal, my lord. So whether is it a civil court, this particular judgment says civil court, quite possible, or any other forum, but not the Motor Accidents Claims Tribunal, my lord. So my first point, my lord, is a very simple point. If I can sum it up, it was a case of murder, my lord. It was a case of murder simpliciter. That being the case, MACT could not and should not have exercised jurisdiction, my lord. Supreme Court is also very clear as to the distinction between murder and accidental murder. Our case falls within a murder. MACT cannot exercise jurisdiction. Honorable Division Bench of Guwahati High Court has made it even more clearer. When a person is wrongfully killed, deliberately killed, MACT cannot exercise jurisdiction. Number one, that's my first point, my lord, the evident absence of jurisdiction of MACT. My second point is that this accident does not fall within 163A because this death, my lord, which has occurred, is not a death that has arisen out of the use of a motor vehicle, my lord. If lordship looks at this compilation again, page 9, page 7, my lord.
Yes.
This was a 1991 Supreme Court judgment.
Yes.
Para 36 of this judgment. Next page. Now, lordship may kindly appreciate for a moment that under section 166, which is the normal section under which claims are filed, the language uses when a death or injury is caused by the use of a motor vehicle. That is 166. So the words used are caused by the use of a motor vehicle. 163A is slightly different because 163A, like I pointed out, uses the expression arising out of use of motor vehicle, not caused by. So in this judgment at para 36, Supreme Court has tried to explain what does this phrase arising out of mean. Para 36, this would show that as compared to the expression caused by, the expression arising out of has a wider connotation. The expression caused by was used in section so-and-so and section so-and-so of the Act. In section 92A, that is the old 163A. In section 92A, Parliament, however, chose to use the expression arising out of, which indicates that for the purpose of awarding compensation under section 92A, the causal relationship between the use of the motor vehicle and the accident resulting in death or permanent disablement is not required to be direct and proximate, and it can be less immediate. This would imply that accident should be connected with the use of the motor vehicle, but the said connection need not be direct and immediate. This construction of the expression arising out of the use of a motor vehicle in section so-and-so enlarges the field of protection made available to the victims of an accident and is in consonance with the beneficial object underlying the enactment. My lord, I'll reiterate what has been stated in the middle, this would imply that accident should be connected with the use of the motor vehicle, but the said connection need not be direct and immediate. It need not be direct and immediate, but there has to be some casual connection, my lord, at least, if nothing else, between the accident and the death that has come out of the accident and the use of the motor vehicle. Point being, my lord, first there has to be an accident. Mere use of the motor vehicle resulting in death is not sufficient. What is required in between is an accident, my lord. Here, very clearly, and I would say admittedly, there was no accident. So, using a motor vehicle resulting in death, what is missing in between is the accident part, my lord. So, in any reading of the matter, I would again humbly submit there was no occasion or no possibility that the learned MACT could have exercised jurisdiction in this matter. Reading the statute as it stands, along with the judgments pronounced by Supreme Court and Honorable Guwahati High Court, it is very clear that this was not a case that should have been adjudicated or taken up by the MACT, my lord. So that is my second submission. That first was it was a case of pure murder. Second was the requirement of section 163A. There are two requirements: accident and use of motor vehicle. Maybe in this case, motor vehicle has been used, but where is the accident? There is clearly, evidently, admittedly, no accident that has occurred, my lord. That is my second submission. Third submission, and just two more submissions, my lord. Third submission is that, notwithstanding anything that I have submitted till now, if Honorable Court does not agree with me for any reason, and Honorable Court decides that maybe it was an accidental murder, Honorable Court decides to forego the requirement of an accident having occurred, yes, and Honorable Court comes to the conclusion that maybe MACT could have exercised jurisdiction in the matter. Even then, there is one more hurdle that the MACT was required to cross to exercise jurisdiction, which is that all and any claims are not entertainable under section 163A. It is only claims where the income of the deceased person does not exceed 40,000 rupees is the claim maintainable, my lord. In this connection, if Lordship looks at page 9 of the compilation, Division Bench of Honorable Madras High Court has reiterated this position. That is a 2009 judgment. Yes. Para 9 of this judgment, my lord. Para 9. Yes. I'll read, my lord. The Supreme Court held in so-and-so case, 2001 so-and-so, that the benefit can be availed of by the claimant by restricting his claim on the annual income up to rupees 40,000. But the later bench did not agree with the findings in so-and-so that if the person invokes provisions of section 163A, the annual income of rupees 40,000 shall be treated as a cap. They held that section 163A, being a social security provision, providing for a distance scheme, only those whose annual income is up to rupees 40,000 can take the benefit thereof. All the other claims are required to be determined in terms of chapter 12 of the Act. In the present case, therefore, section 163A cannot be invoked since admittedly the claimant's income exceeds the rupees 40,000 limit. So there is a limit, my lord, which has to be adhered to if a claim is filed under 163A. Has the limit been breached in this case, my lord? The answer is at page 18, my lord, of the memo of appeal. Page 18, 18. Page 18 is part of the claim petition. Yes. So if everything in the claim petition is taken to be true, even then, Lordship will see at page 18, right at the bottom paragraph, subclause A, monthly income 5,000. subclause A, my lord, right at the bottom. Monthly income 5,000. So 5,000 per month, my lord, translates into 60,000 per year.
Yes.
So that being the case, 60,000 per year amounts to a breach of the 40,000 limit, my lord.
But here is said net income.
My lord.
Here it is said net income.
Where, my lord?
Yeah. Annually, so one third of income. Net income per annum 40,000.
No, this is the deduction that is conducted. Annually, one third of income must have been deducted.
Yes.
So this is after deductions, etc. My lord. Deduction being that dependency, depending on dependency. No, but that is not relevant, my lord. It is the annual income, the stated annual income, which is relevant. The stated annual.
About the gross or net?
My lord, the Supreme Court says the annual income, my lord. It says the annual income cannot be more than 40,000. Here, annual income, admittedly, is 60,000. So, to answer, I will not be in a position to answer Lordship's question because I am not guided by anything that Supreme Court has said. Supreme Court says your stated income.
If Supreme Court says, or even the Act says,
yes, my lord,
40,000.
Yes, my lord.
In this case,
so 40,000.
He or she said 60,000.
60,000.
But then there are deductions, whatever.
If Lordship looks at the deductions, this is a deduction that is more properly applied under Section 166. Depending on the number of dependents, right, you deduct 1/3 or 1/5 or whatever it is, my lord. This is not a deduction. Number one, this is not a deduction that is a factor under 163A. And even if it is to be considered as a factor under 163A, the deduction is not a deduction for income tax or gratuity or anything of that sort. This is just a deduction for the purposes of claiming compensation under MV Act because it depends on dependency. This is clearly dependency. 1/3 of the income. What is 1/3? It is the dependency that has been deducted, my lord. So depending on how many family members he's said to have, they have deducted 1/3. But the fact remains that the stated income is 60,000. Supreme Court has not said that after deductions your income should be 40,000. If your income is 40,000, then beyond that you cannot claim under 163A. So my third point, my lord, is that the case that has been placed before the MACT itself shows that it could not have been filed under 163A. Number 3, my lord, and my last submission is that, again, my lord, leaving everything aside, again, my lord, notwithstanding anything that I may have submitted till now, if lordship, from the goodness of lordship's heart, decides that a death has occurred one way or the other and some sort of compensation is to be paid, the awarded amount, which is 11 lakhs plus 11 lakhs something plus 9% interest, I think, that has to go, my lord. The only compensation that can be allowed that is payable under 163A is 5 lakhs rupees. There has been an amendment.
That's a solution?
Yes, ma'am. No, not really solution. If lordship looks at page 48 of the memo of appeal, it's a amendment of the act itself. This was in 2018. Prior to that, we had that structured formula basis.
Yes.
That has been done away with. Now, second schedule has been amended. If lordship turns the page, the English version.
Okay. Page 49.
Yes, page 49. I'll read, my lord. This is dated 22nd May 2018. In exercise of the powers conferred by so-and-so of Section 163A of the Motor Vehicles Act so-and-so, central government, keeping in view the cost of living, hereby makes the following amendment to the second schedule to the said act, namely, in the Motor Vehicles Act 1988, for the second schedule, the following schedule shall be substituted, namely, so initially, my lord, there was a structured formula basis. Now that is gone, my lord. Now we have this schedule for compensation for third-party fatal accident injury cases claims. Number 1, fatal accidents. Compensation payable in case of death shall be 5 lakh rupees. Number B, accidents resulting in permanent, not relevant for us, my lord. So in case of a death, in case there is any claim that is payable for that death under 163A, the maximum that can be awarded is 5 lakh rupees. So this is my submission of last resort. My first submission is obviously that it cannot, this claim should not and could not have been entertained by MSCT. It is a case of murder simpliciter. Supreme Court and Guwahati High Court are very clear that in case of death arising out of the felonious act of a person, MSCT cannot exercise jurisdiction. That was my first submission. Number two, the requirement under 163A that there has to be an accident that gives rise to death or disability. There is no accident itself. That is my second submission. Third submission was that in this case, income admittedly was 60,000, which is beyond the cap of 40,000 that is provided under law. Fourth submission, notwithstanding any of these issues, any of these aspects, any of these submissions, under any circumstances, compensation could not have exceeded 5 lakh rupees. That is the statutory limit under 163A. That's all.
Yes. Can I make my submission, Your Lordship, please? Your Lordship, first of all, I would like to submit before this Honorable Court regarding the appeal which has been filed by the appellant. This is not maintainable, first of all, Your Lordship. Maintainable in the sense, Your Lordship, the grounds which he has assailed, this is totally already decided by the Honorable Supreme Court regarding all the points. So first of all, my learned friend has submitted before this Honorable Court that this is a case, not a case of accident. This is a murder, he has said. But whatever, I want to take with this Honorable Court into the case of his submission, what he has made regarding this Rita Devi's case, Your Lordship. So Rita Devi's case, in his appeal also he has mentioned, Your Lordship, this is a very good case, and my case also have been decided only on the basis of this case itself, Your Lordship. If Your Lordship come to the page 40 of the judgment appeal, Your Lordship. How the tribunal has come to the conclusion, it is there, Your Lordship, issue number 4, how it is decided. Can I read, Your Lordship, please? This is page number, appeal, page number 40. This is 24. Second point only.
Yes.
Issue number 4. Whether death of the son of claimant was due to accident arising out of use of the motor vehicle, Your Lordship. So we are now in a stage that whether this is a clean accident or not. In a sense, this is not a clean accident, Your Lordship. But whatever it has been provided by the Honorable Supreme Court and regarding the law, it has been enhanced. The power and jurisdiction of the Honorable Tribunal has been enhanced. Enhanced in the sense on the basis of settled law, Your Lordship. So settled law is that some accident may be direct or some may be indirect. So use of the vehicle. So whether in the context of use of the vehicle, he has been murdered or not, that is to be decided in this case. So this, the learned tribunal has decided this point, Your Lordship. So I'm coming to that. Use of the motor vehicle. Claimant contended that death of the son of the claimant arose out of the use of the motor vehicle. So that is our contention already there, Your Lordship. Use of the vehicle, where he was kidnapped along with the driver Shri Lutfur Rahman with the vehicle number ML04S so and so. Dead bodies were recovered on the next day. So here, Your Lordship, I want to make a submission that 2 persons were died on the same day in the same incident. And just I want to remind this Honorable Court that insurance did not follow up their case when the driver's case was already been settled. The same accident. Like this, likewise, my case, the dead body has been, both the dead bodies has been found from there. Same place, but they have not come forward for appeal. That was already been decided. In the second case, they have come forward and they choose to make a appeal before this Honorable Tribunal. Anyway, Your Lordship, So this is next. Claimant contended that the son of the claimant was a handyman of the said vehicle, and as such, his death arose out of the use of the vehicle. Point number 27. OP number 2 contended that the son of the claimant did not die in a motor vehicle accident. This has already been challenged there, Your Lordship. Contended. Already their contention is recorded. But was abducted by some miscreants and later on killed. Hence, the death of the son of the claimant did not arise out of the motor vehicle. It was their contention also there, Your Lordship. So, OP number 2 contended further that the deceased Kobiruddin was at the time of the alleged incident traveling in the sumo as gratuitous passenger, not in a capacity of driver, and he had no authority to be in the vehicle, although the claimant made a feeble attempt to show that deceased was working as a handyman in the said sumo, and even CW2 categorically stated that the deceased was not a driver of the sumo vehicle in question, but a driver of the Maruti vehicle belonging to the same owner. So there was our contention, and in the evidence it is there, Your Lordship will find that he was working under the same owner, and on the same day he has come with his own relative. Both were relative, Your Lordship. They were the cousins, and one has come along with other, and the incident happened on the same day, Your Lordship. So he was working along with the under the same owner, Your Lordship. OP number 2 contended further that the identity of the dead body of Kobiruddin was also not identified with certainty, so it is doubtful whether the dead bodies actually belong to Kobiruddin. Next, CW1 Abdul Sattar, the father, Your Lordship, who is the claimant of the instant case, stated that his son Kobiruddin at the time of incident was a driver under one person, namely Sri Shi of Rimbai village, and on the evening of so-and-so date, the driver of the vehicle called his son to go along with him, and on the said evening, some miscreants kidnapped the vehicle Tata Sumo along with driver and his son. On the next date, on 1/1/2020, the dead body of his son and the driver was found by the police, Your Lordship. Next page. He also stated that police registered the case after the incident as UD case number 1/1/1/2020 under Caleriat PS, and after all the formalities, the police handed over the dead body of his son to his relatives. In his cross-examination, he stated that his son was traveling in a vehicle which he was abducted and his body thrown in the jungle. He admitted that his son was not the driver of the sumo in which he was traveling with Sri Lutfur Rahman, but he is a driver of another vehicle of the same owner. He denied that his son did not die in a motor accident. CW number 2, MD Aziruddin stated that late Kobiruddin was his nephew, and on 31/12/2009, his nephew and his brother's son Lutfur Rahman were both traveling in a sumo vehicle, and thereafter some miscreants took the vehicle, and later their dead bodies were found at Ladrimbai on 1/1/2010. After the completion of the postmortem examination and all formalities, they took their dead bodies to their respective village. The inquest report was exhibited by CW2 as exhibit number 2 and his signature exhibit 2/1. Further, CW number 2 stated that he knows the owner of the sumo vehicle barely, Sri Shi of Rimbai village, and he engaged late Kobiruddin to work as a driver at a salary of ₹5,000 only per month. In his cross-examination, he stated that as per the inquest report, the deceased Kobiruddin body had several stab injuries. He also stated that the deceased Kobiruddin was not the driver of the sumo vehicle, but he was the driver of the Maruti vehicle of the same owner. He admitted that the deceased did not die in a motor vehicle accident but was murdered. CW number 3, Dr. Lokai Pasha, was posted at Caleriat CSC, and on 2/1/2010, she conducted the postmortem on the body of the deceased Kobiruddin, aged 19 years. The body was brought by SISK Linkoi with a UBC 146-1 Nogrum. On examination of the body, she found some injuries. I'm coming to the next point, number 37, Your Lordship, on it. As per CW number 3, in his opinion, the cause of death is due to shock and hemorrhage as a result of severe injury by sharp object. She exhibited the postmortem report as exhibit 3, and her signature is in exhibit 3/1. CW number 4, what he stated. Inspector Lumlangling Linkhoi is the IO of the instant case, and he was holding the post in charge of Ladrimbai outpost in the year 2010. He stated that on 1/1/2010, once she lodged FIR before him, alleging that his driver Sri Lutfur Rahman along with his helper Sri Kobiruddin were found missing along with some sumo bearing number so-and-so from Rimbai Road, and on receiving the said FIR, he entered in the GT entry of the outpost and forwarded the same to the OC Caleriat, who in turn received the registered the same by GT&T number so and so, dated so and the case was registered as Caleriat PS case number 11/2010 under section 364, 302, 201, 379, 34 IPC, and he was endorsed to take up the investigation. So the case has been, Your Lordship, my submission is here, that case has been, it is evident on record, that case has been registered under section 364, that is kidnapping and murder, thereafter 302 also there, and 379 is also there, Your Lordship. The FIR dated 1/1/2010 exhibited by CW number 4, exhibit number 4, and he can identify the signature of so and so FIR. Next point number 40. He stated the duty.
There is no doubt as to what happened.
Yes.
That the deceased was murdered.
Murdered, yes.
That is, I don't. Yes. There is no, objection, or there's nothing contrary to that.
There is no contradiction, my lord.
But the only thing is how and what manner he
No,
did.
whether
while the use of vehicle or not.
Use of vehicle or not.
So
that is the
that
question.
How to it.
Yes, Your Lordship. So in that context, the learned tribunal has come to the conclusion with the basis of the evidence only, evidence of all these evidences. She come to the conclusion that yes, it is although it is a murder, but the murder has been happened out of the use of the vehicle. So now I want to come, Your Lordship. My learned friend wants to capitalize his appeal only on the basis of only one sentence, my lord. This is regarding the statement of CW number 4. This is page number 33, my lord. Page number 33 of the appeal. So how is capitalizing? Just I want to clarify this honorable court that what is the meaning of that, Your Lordship, and how it has come to the conclusion. So I'm only going to the page 34, Your Lordship. Please come to the page 34.
Yeah.
One being endorsed, this is the statement of, this is chief, Your Lordship, chief of the CW number 4. One being endorsed, I investigated the case, and on completion of my investigation, I have submitted the FF in FR. During my investigation, I recovered the dead body of both the drivers and the handyman from Leshkar River, and the vehicle was recovered from Moirankaning, one being left abandoned by the miscreants, Your Lordship. I had also contacted the inquest of the body. The dead bodies were identified, one of their relatives by the name Aziruddin, that is CW number 2, Your Lordship. The inquest was prepared by me, and exhibit 2/2 is my signature, and on exhibit 2, after the inquest, the dead body was sent for postmortem to CHC Caleriat by me. After the postmortem, the dead body was handed over to the relatives. Due to non-availability of evidence or clue, the case was returned in FR, my lord. So there was no clue, there was no arrest, nobody has been arrested, no interrogation, nothing else. So how can he come to the conclusion? Just only presumption, and whatever the clues he has found, he has submitted his report. So according to me, just he has given an opinion only, this is presumption only, the last sentence. According to me, the miscreants have murdered the said driver and the handyman, maybe with the intention of stealing the vehicle. This is his FR. And exhibit 5 is the final report filed by me, and exhibit 5/1 is my signature, Your Lordship. So this is a clear cut, Your Lordship. His presumption or whatever his investigation report is there, he presumed, he has mentioned there in chief. So my point is here, Your Lordship, whether the insurance has refuted this exhibit 5 anywhere in the cross-examination.
Yes.
Specifically, whether they have refuted or challenged this exhibit 5. Nowhere they have been challenged, Your Lordship. In the cross-examination, this is very much intact, Your Lordship. So last line, I am coming to that, Your Lordship. Page number 34 only. Later stated that I am not sure whether the Tata Sumo is a tourist or a private vehicle. The next day, the said vehicle was found from Moirankaning. It is not a fact that one of the body does not belong to late Kabiruddin. So it is the first sentence, Your Lordship, and it is the same sentence is continuous sentence, Your Lordship. And it is also not a fact. He want to qualify actually the previous sentence. It is also not a fact. He wants to qualify the previous sentence also along with this, that the reason for the murder of the deceased was for the purpose of stealing of the vehicle. I may say here, Your Lordship, this is just only mistake in typing. Otherwise, one not should be added here. Was not for the purpose of stealing. He should have stated how it has gone actually in the evidence. I cannot say, but my submission will be that the honorable court shall presume in this way only, because in the chief it is already there and it is not been refuted by the insurance. And secondly, this sentence, only capitalizing this sentence, it is not enough, your lordship. So my humble submission is that this is a case which has been arising, the murder has been arising out of the intention of these persons, and this is furtherance of a felonious act. Secondly, they want to take out the vehicle, and it is in detail evidence of the CW number 4. He has stated that in the process of stealing the vehicle, they might have, and the headlight also been spoiled. That is why they have abandoned the vehicle and they left away, your lordship. This is the case, your lordship. Now, what my learned friend has stated, your lordship, regarding the cap, I am coming to that page. Regarding the income, what my learned friend has stated. This is already decided by a very remarkable judgment, your lordship, for all our case. Every MSCT case is decided on the basis of that. So how it is being stated and how it is decided there only, your lordship. This is page number 125, my lord.
Yes.
This is para G, your lordship. Motor Vehicles Act 1988, 166 and 163A. Both sections are covering, your lordship, here. Your lordship got it. Page number 125.
These are just head notes.
Huh?
These are head
notes. Yeah, later on actually it is there. It is held. I'm going to, this is para number 25 and 26, your lordship. Detail is there in 25 and 26. This is page number 134, your lordship.
Yes.
So this is regarding the deduction what he has stated. We have already noticed that the personal and living expense, this is on the living expense, your lordship.
Yes.
How it has been living expenses, this is also relevant in this case, your lordship. We have already noticed that the personal living expenses of the deceased should be deducted from the income to arrive at the contribution to the dependents. No evidence need be led to show the actual expense of the deceased. In fact, the evidence in that behalf will be wholly unverifiable and likely to be unreliable. The claimants will obviously tend to claim that the deceased was very frugal and did not have any expense habits and was spending virtually the entire income on the family. In some cases, it may not be so. It may be so. No claimant would admit that the deceased was a spendthrift, even if he was so. Page number 26. It is also very difficult for the respondent in a claim petition to produce evidence to show that the deceased was spending a considerable amount of income on himself, or that he was contributing only a small part of the income on his family. Therefore, it became necessary to standardize the deductions to be made under the heads of personal and living expenses of the deceased. This led to the practice of deducting towards personal and living expenses of the deceased 1/3 of the income of if the deceased was married and 1/2 of the income if the deceased was a bachelor. This practice was evolved out of experience only, logic and convenience. In fact, the 1/3 deduction got statutory recognition under the second schedule to the Act in respect of the claims under section 163 of the Motor Vehicle Act 1988. But percentage of deduction is not an inflexible rule and offers merely a guideline. This is regarding the deduction what my friend has said. This is just only offers a guideline only, your lordship. Now please, your lordship, come to the paragraph 34 of this judgment, your lordship. Paragraph 34.
Yes.
The Motor Vehicle Act 1988 was amended by Act 54 of 1994, inter alia inserting section 163A and the second schedule with effect from 14/11/1994. Section 163A of the MB Act contains a special provision as to payment of compensation on structured formula basis, as indicated in the second schedule to the Act. The second schedule contains a table prescribing the compensation to be awarded with reference to the age and income of the deceased. It specifies the amount of compensation to be awarded with reference to the annual income range of 3,000 to 40,000. It does not specify the quantum of compensation in case the annual income of the deceased is more than rupees 40,000. That schedule is not mentioned more than 40,000. What Supreme Court says later, but it provides the multiplier to be applied with reference to the age of the deceased. The table starts with multiplier of 15, it goes up to 18, and then steadily comes to down to 5. It also provides the standard deduction as 1/3 of the personal living expenses, 63A. It is possible to calculate, here it is my case, your lordship. It is possible to calculate the compensation on the structured formula basis, even where the compensation is not specified with reference to the annual income of the deceased. Even if it is not mentioned also, it can be calculated, your lordship, or is more than 40,000. So what my learned friend has argued, this case actually this is not maintainable. So this is already be decided by this case itself, your lordship. So point number 3, what he has argued, your lordship, I think he will be satisfied with that. And another point he has raised, your lordship, regarding the maintainability. Regarding the application of amended act, your lordship. So there is a case, your lordship, this is in the High Court of Sikkim, Gangtok. This is dated. Please give this. So when any act is amended, your lordship, so it will be prospective or it will be retrospective. This is a question, your lordship. So I think, your lordship,
the act will provide for that.
Yes, your lordship.
I said the act will provide for that.
Yes, yes, yes. So in this case, this is also an MSCT case decided. This is also new amended act 166(3) was challenged, under challenge. So the Honorable Supreme Court, the Sikkim High Court has taken the shelter or based in one case. This is in paragraph number 11, my lord, of this judgment.
Yes.
It may relevantly be stated here that in Assistant Excise Commissioner Kottayam and others versus Ittapan, Sherian and another, the Supreme Court was considering the amendment of Rule 13 of Kerala Abkari Shops Departmental Management Rules 1972. It was held therein that an amendment is prospective. The relevant paragraph is extracted below. There is profuse of judicial authority on the proposition that a rule or law cannot be construed as retrospective unless it expresses a clear or manifest intention to the contrary. In another case also is here, in CIT versus Batika Township Private Limited, court speaking through a constitution bench observed as follows. That was the paragraph 22 of that, your lordship, 22, 21, 22, paras 28, 29. So 28 para is mentioned here. Of the various rules guiding how a legislation has to be interpreted, one established rule is that unless a contrary intention appears, a legislation is presumed not to be intended to have a retrospective operation. The idea behind the rule is that a current law should govern current activities. Law passed today cannot apply to the events of the past. If we do something today, we do it keeping in view the law of today and in force, and not tomorrow's backwards adjustment of it. So this is already decided, and your lordship is very much aware regarding that, whether it will be prospective effect will be there or retrospective effect. There is no retrospective in the, what is the notification he has cited here or submitted before this honorable court. There is no link because there is no specific anything mentioned there that this is retrospective effect. It must be prospective. Our case is actually previous one. This is 2010, my lord. So whatever this submission, and on the basis of my submission, I am concluding here again, your lordship, whatever the tribunal has done, this is done, a very reasoning judgment has been passed on the basis of evidences, and moreover, your lordship, regarding the dissatisfaction of my friend, what he has stated regarding the cap, this honorable court will be satisfied with that judgment of the honorable Supreme Court, and this appeal shall be dismissed, your lordship, and claim shall be positive. And one more submission, your lordship, I want to add here. In the appeal, this is wrongly has been, my friend has mentioned that the interest part he has mentioned here, that is of 8%. Many times he has mentioned this is of 8%, but this is not of 8%, Your Lordship. If you go by the award which has been passed, this is 9%, Your Lordship. Please come to the award page, Your Lordship. Just time to remind. This is page 47, Your Lordship. You might have overlooked, I think, Your Lordship. Page 47, my lord.
Nothing is said about interest.
Yeah.
There's no quarrel about interest.
No, thing is, he has not done, but in the appeal he has mentioned, that is why I clarified this.
It's not pressed that.
Yes, Your Lordship. This is the only, as per award, Your Lordship. High level.
Lordship, I'll take 2 minutes, my lord, just for 2 very quick responses.
Yes.
My lord, my first contention, my first objection against this claim petition was on the issue of maintainability, that an MACT tribunal could not have taken up or adjudicated this matter, my lord. My friend's response, and in support of that, I had highlighted the law, Rita Devi's case, division bench judgment of the Honorable Guwahati High Court, plus the statute itself, my lord. In response, my friend has taken, my lord, through the judgment, that is issue number 4, the decision of the MACT under issue number 4. Yes. With respect, my lord, I need to point this out. How is that a response to my contention, my lord? We are examining the validity of MACT's judgment in this appeal. And where I have stated that MACT did not have jurisdiction, you cannot go back to MACT's judgment to counter my appeal. We are examining the validity of MACT's judgment. Point being, my lord, there is no viable answer that has been extended to my contention that MACT should not have exercised jurisdiction, my lord. My friend has attempted to focus, number 2, my friend has attempted to focus on the use of the motor vehicle. The issue number 4 that was framed by MACT was whether death occurred out of use of motor vehicle. My lord, use of motor vehicle is one requirement under 163A. My first submission, if Lordship recalls, was under 163A, there are 2 requirements. I will not trouble Lordship to open 163A again, but I will, if I am to take the trouble, 163A, notwithstanding so and so, so and so, so and so, the owner of the motor vehicle of the authorized insurer shall be liable to pay in the case of death or permanent disablement due to accident arising out of the use of motor vehicle. So there has to be an accident arising out of use of motor vehicle which has led to death or disability, my lord. There are, like I had submitted some time back, there is a death, no dispute about that. There was use of motor vehicle. At some point the deceased person was sitting in the motor vehicle. But the second component, there has to be an accident. That is not there, my lord. That is clearly not there. In no reading of the matter, in no twisting of facts, can an accident be placed for Lordship's consideration. There was no accident. In fact, the portion read out by my friend, the evidence of CW2, CW2's evidence says, he agrees, my lord, that there was no para 35 of the judgment. He admitted that the deceased did not die in a motor vehicle accident but was murdered. That is at page 41, where the claimant's witnesses themselves are admitting. Para 35 of the judgment, page 41 of memo of appeal, last line. He admitted that the deceased did not die in a motor vehicle accident but was murdered. So the point is very simple, my lord. The point is, a judicial adjudication cannot be conducted in a vacuum. It has to be based on statute, on law. The statute, a plain reading of the statute shows very clearly there are 2 requirements: accident, number 1, number 2, arising out of the use of motor vehicle. All of this should have contributed to the death. There is no accident. Witnesses say there was no accident, there was a murder, my lord. So that being the case, my point on maintainability still remains. My point on maintainability being very simple, that this was not a case of accidental murder. This was a case of murder simpliciter. First response. My second response, and if I'm allowed to just finish up my first response regarding the evidence of CW4, the IO. CW4, the IO, my lord, in his cross-examination, the portion I had highlighted, the last line, where he admits it is also not a fact that the reason for the murder of the deceased was for the purpose of stealing the vehicle. In other words, in very simple terms, he says there was no intention of theft. The intention was clearly to murder these people, my lord. The fact that vehicle was found next day, if the intention was theft, vehicle would be somewhere else, my lord. Vehicle would never have been found. Vehicle being found next day forced the IO to say that there was no intention of theft. My friend's response in respect of the evidence of the IO is to say that there was a typing mistake. There should be a not somewhere there. We have to go by the records, my lord. The records very clearly show the admission of the IO that there was no intention of theft. The intention was always murder, my lord. My second response, very quickly, my lord, is regarding the Sarla Verma judgment, which my friend had referred to. My friend had
This is regard to quantum.
On that 40,000 cap, my lord, 40,000 cap. Para 34 was referred to.
Yes.
But does para 34 actually say what my friend claims it says? It does not. If I'm allowed to read para 34 slowly, my lord. Para 34 of Sarla Verma, my lord.
Yes.
The Motor Vehicles Act 1988 was amended by so-and-so, inter alia, inserting section 163A and the second schedule with effect from so-and-so. Section 163A of the MV Act contains a special provision as to payment of compensation on structured formula basis, as indicated in the second schedule to the Act. The second schedule contains a table prescribing the second schedule contains a table prescribing the compensation to be awarded with reference to the age and income of the deceased. It specifies the amount of compensation to be awarded with reference to the annual income range of rupees 3,000 to rupees 40,000. I'll just pause, my lord. Supreme Court is itself admitting that the second schedule does not contemplate or does not provide any calculations for an income beyond 40,000. Number one. Moving on, it does not specify the quantum of compensation in case the annual income of the deceased is more than rupees 40,000. Again, a clear observation, acknowledgement by the Supreme Court that there is no quantum of compensation provided when the income is beyond 40,000. But it provides the multiplier to be applied with reference to the age of the deceased. The table starts with a multiplier of 15, goes up to 18, and then steadily comes down to 5. It also provides the standard deduction as 1/3 on account of personal living expenses of the deceased. Therefore, where the application is under section 163A of the Act, it is possible to calculate the compensation on the structured formula basis, even when the compensation is not specified with reference to the annual income of the deceased or is more than rupees 40,000. We are talking about the compensation, my lord. Even where the compensation is not specified with reference to the annual income of the deceased or is more than rupees 40,000 by applying the formula so and so, so and so. This 40,000 is not the income, is the compensation, even where the compensation is not specified with reference to the annual income of the deceased or is more than rupees 40,000, my lord. We have to go by the Act. The Act itself is very clear. Second schedule at one time contained a table where certain formulas were present, formulas being only up to the limit of 40,000. That being the case, any income beyond 40,000 is exempt or is outside the purview of that table, is outside the purview of 163A. Madras High Court in that judgment, 1991 judgment which I referred to, made it even more, could not have made it more clearer that because your income is above 40,000, we cannot exercise jurisdiction, my lord. My last response. So 40,000, the cap. There is a cap, my lord. It cannot be breached. Madras High Court has made it very clear. It cannot be breached. This reading of para 34 of Sarla Verma, incorrect reading, cannot serve to convince this honorable court that there is no cap. Cap is there evidently. Madras High Court is acknowledging that cap, my lord. And my last response is on the notification of 2018, whereby the second schedule was amended, my lord, and that 5 lakh rupees compensation was prescribed. My friend's response to that is to point out that amendment cannot be retrospective, it has to be prospective. There is no dispute with that. There is no dispute with that proposition of law. But that principle, that proposition of law, is only applied or is only useful when there is a question that arises of upsetting settled positions. In the sense, if I'm allowed to explain, today a judgment is passed in my favor on some issue, my lord. 1 year later, Supreme Court passes a similar kind of judgment on the similar kind of issue, because of which it is found that the judgment that was passed in my favor was incorrectly passed. Or there is a change in the law, my lord. There is a change in the applicable law after 1 year. The principle that amendment cannot apply retrospectively is only for a situation where the benefit I have got out of the judgment is not to be disturbed. So today, Honorable Court gives me a certain relief in a matter. 1 year later, there is an amendment of the law. Can the respondents now come and say that the law has changed, that benefit which I got has to be taken away from me? That is not possible. That is not possible because that amendment conducted 1 year later will not apply retrospectively, my lord. That is the only reason it is said repeatedly, and I completely agree with it, that amendment cannot apply retrospectively. Here, what has happened is, 2018, there was that notification published, which amended second schedule. 2024, the judgment was passed by MACT. So on the date the judgment is passed, the MACT has to apply the law as on that date, my lord. MACT has to apply the law on that date. In 2024, when the judgment was passed, 2018 amendment was already in force. So Honorable MACT was not in a position to say that I will not apply the 2018 amendment. Passing a judgment in 2024 means 2018 amendment has to apply. That 5 lakhs upper limit has to be made applicable. So if failing everything else, if compensation is to be passed in favor of the claimant, it cannot exceed 5 lakhs. Amendment not applying retrospectively, prospectively, etc., has no place in this matter. During the pendency of the matter, amendment was conducted. At the conclusion of the matter, learned MACT was required to apply that amendment, my lord. So to sum up, my lord, in 2 lines: number 1, claim itself is not maintainable, and no viable response has been given in reply. Claim is not maintainable. Number 2, even if claim is to be maintainable, my lord, what makes it not maintainable is the law and that 40,000 upper limit of the income. Number 2, even if it is even if it is held maintainable, 5 lakhs is the maximum that the claimant can be entitled to, my lord. So I close my submissions.
Can I make a small reply? Can I make a small reply? Just only the contention of accident and arising out of the accident. Same thing, I am basing on my submission on the Rita Devi's case, because that is also same case. It has been already decided by the Honorable Supreme Court. And regarding other submissions, whatever I have submitted, I conclude, Your Lordship.
You file your written notes.
Very well, very well. A week's time may be given.
Mr. S. General, Counsel for the Appellant, Mr. Nai Chaudhary for the respondent. order was passed to proceed ex parte against respondent?
Yes, yes. On 28th March this year, my lord.
Respondent to hearing have been concluded. Parties have paid for filing of written argument. Accordingly, this is matter of the 1 week.
Obliged.
My lord.